Convention on the Rights of the Child, adopted by General Assembly Resolution 4425 of November 20, 1989. Article 38. 1. States parties undertake to respect and ensure compliance with the norms of international humanitarian law applicable to them in the event of armed conflicts and relevant to children. 2. The participating states shall take all possible measures to ensure that persons under the age of 15 do not take direct part in hostilities. 3. The participating states shall refrain from conscripting any person under the age of 15 to serve in their armed forces. When recruiting from among persons who have reached the age of 15 but who have not yet reached the age of 18, states parties shall seek to give preference to older persons. 4. In accordance with their obligations under international humanitarian law related to the protection of civilians during armed conflicts, the participating states undertake to take all possible measures to ensure the protection and care of children affected by armed conflict. Article 39. States parties shall take all necessary measures to facilitate the physical and psychological recovery and social reintegration of a child who is a victim of any kind of neglect, exploitation or abuse, torture or any other cruel, inhuman or degrading treatment, punishment or armed conflict. Such recovery and reintegration should be carried out in conditions that ensure the health, self-respect and dignity of the child. Article 40. 1. The participating states recognize the right of every child who is considered to have violated criminal law, is accused or found guilty of violating it, to be treated in a manner that promotes the development of a child's sense of dignity and importance, strengthens respect for human rights and fundamental freedoms of others, and which takes into account the child's age and desirability, facilitating their reintegration and fulfilling their useful role in society. 2. To this end, and taking into account the relevant provisions of international instruments, states parties, in particular, ensure that a. No child was considered to have violated criminal law, was not accused or found guilty of violating it because of actions or omissions that were not prohibited by national or international law at the time of their commission. B. Every child who is deemed to have violated or is accused of violating criminal law has at least the following guarantees. I. Presumption of innocence until proven guilty according to the law. E. Immediately and directly informing him of the charges against him and, if necessary, through his parents or legal guardians, and obtaining legal and other necessary assistance in the preparation and implementation of his defense, i.e., an urgent decision on the matter under consideration by a competent, independent and impartial body or judicial authority during a fair hearing in accordance with the law in the presence of a lawyer or other relevant person, and, if this is not considered contrary to the best interests of the child, in particular, taking into account his age or the position of his parents or legal guardians. If freedom from coercion to testify or confess guilt. Examination of the testimony of prosecution witnesses either independently or with the help of other persons, and ensuring equal participation of defense witnesses and examination of their testimony. V. If it is considered that the child has violated criminal law, a re-examination by a higher competent, independent and impartial body or judicial body in accordance with the law of the relevant decision and any measures taken in this regard. V. Free assistance of an interpreter if the child does not understand the language used or does not speak it. V. Full respect for his privacy at all stages of the proceedings. 3. States parties shall endeavor to promote the establishment of laws, procedures, bodies and institutions directly relevant to children who are considered to have violated criminal law, are accused or found guilty of violating it, and in particular, a. The establishment of a minimum age below which children are considered incapable of violating criminal law. B. If necessary and desirable, taking measures to treat such children without recourse to judicial proceedings, subject to full respect for human rights and legal guarantees. 4. It is necessary to have such various measures as care, guardianship and supervision regulations, advisory services, probation appointment, upbringing, education and vocational training programs and other forms of care replacing care in institutions in order to ensure that the child is treated in a way that would correspond to his well-being, as well as his position, and the nature of the crime. Article 41. Nothing in this convention affects any provisions that are more conducive to the realization of the rights of the child and may contain a. in the law of the state party, or b. in the rules of international law applicable to that state.